As a lawyer, Citizens United was one of the most surprising Supreme Court decisions of my life because it radically upended settled constitutional understandings, as well as bipartisan agreement that had been reached here in the Senate regarding appropriate limitations on corporate speech. When the McCain-Feingold law passed in 2002, just 6 years prior, it showed a strong bipartisan intent to rein in corporate spending, to rein in and manage spending by interests of all kinds in politics. That's why I was shocked when, in the opinion in Citizens United, it was joined by the so-called originalist or strict constructionist members of the court. The originalist mode of interpretation of the Constitution attacks every question by asking a common question. Would the framers have thought the action or law being challenged before the Supreme Court is constitutional? That's why if you had asked me in 2008, looking at Citizens United at the issues presented to the court, whether an originalist interpreting the First Amendment would have found the corporate electioneering regulations this body had adopted in McCain-Feingold to be valid, it seems to me there was only one possible answer, and that was yes. Our founding fathers recognized corporations are creatures not endowed like the rest of us with inalienable rights. They are rather fictional legal creatures, creatures of legislative grace. Were this not the case, the corporation, whose name is Citizens United, the corporation that was at issue in this decision, wouldn't have stopped at simply making a movie attacking Hillary Clinton, but would have actually cast a vote against Hillary Clinton. Of course, it couldn't. Corporations don't, Mr. President, have bad hair days. Corporations don't have tasteless ties. Corporations don't have moods and opinions. Corporations are not people. They exist as people only in legal fiction. And I would note the First Amendment states, Congress shall make no law abridging the freedom of speech nor of the press. If the freedom of speech included fictional entities, non-human entities like corporations, there would have been no reason to separately affirm that the press also enjoyed that freedom, granted to real, living, breathing individuals. In my view, then, Mr. President, Citizens United was wrongly decided. As shown through a long line of legislative and judicial interpretation, a view of corporations as having First Amendment rights that are limited and can and should be limited, more than can be limited for real, living, breathing individuals, has remained the dominant one throughout our modern history. In 1907, the Tillman Act prohibited campaign contributions by corporations. In 1947, the Taft-Hartley Act prohibited expenditures and the application of this law further. It was upheld by the court in 1957 in U.S. v. Automobile Workers. When the Supreme Court first made the leap to the expenditure contribution distinction in Buckley v. Valeo in 1971, even then it left intact the long-standing distinction between the First Amendment rights of living, breathing individuals and corporations, legal, fictional persons. The 82 case of FEC versus National Right to Work Committee. In that case, Justice Rehnquist wrote for a unanimous court that it was proper to treat corporations more restrictively than people. Oh, how I wish that were the majority opinion of the court today. The further analysis in 1986 in FEC versus Massachusetts Citizens for Life. Those striking down restrictions on speech by a pro-life organization actually underscored the originalist understanding that when the Constitution protects corporate speech, it only does so as a proxy for the underlying free speech rights of real, living, breathing individuals. In that case, a nonprofit organized and funded specifically for the purpose of bringing about a political goal, pro-life policies, was seen as having free speech rights only because of the rights of those individuals who funded it and organized it. When we talk about a corporation's First Amendment rights, then we should be using shorthand for the First Amendment rights of those who are its shareholders or who own it or who control it. The corporate individual distinction was even again affirmed as recently as 1990 in the Austin case. The constitutional history of limitations on corporate speech was so clear that the Supreme Court had upheld the McCain-Feingold Act in 2003, just a bare 6 years before they struck it down. What possibly could have changed in those intervening years that would be so convincing to an originalist mindset? I don't know. In my view, this decision did not make sense. But I do know that campaign finance, which was a bipartisan issue in this chamber in 2003, where Senators Feingold and Senator McCain, a Democrat and a Republican, led a strong bipartisan coalition to rein in the negative influence of special interest money. That has changed. That has shifted to today, sadly, a starkly partisan issue.